This failure to follow procedures not only leads to frustration and violence, but also allows myriad serious problems to fester until they reach a breaking point. It's recently been reported that accusations of sexual abuse and assault by jail staff were the subject of more than half of the cases filed in state Supreme Court under the Adult Survivors Act. A motion filed by the Legal Aid Society earlier this month alleges young adults in custody are systematically denied the opportunity to attend school, and there are ongoing lawsuits regarding the environmental conditions at Rikers Island, the denial of medical care, and the extreme high rates of use of force by staff. The available data on grievances filed by people in custody demonstrates these issues weren't unknown. They've just been unaddressed. Our analysis shows that grievances have been rising over the last 4 years, especially complaints coming from a vulnerable population housed in mental health observation units. Of the complaints that DOC deems subject to the grievance process, about 30% relate to the provision of medical care. Of the complaints that aren't handled under the formal grievance process, a majority of complaints are against staff, reports of assault or sexual abuse, or complaints related to housing and a fear for personal safety. Today, we hope to learn more about how DOC and CHS uses this information and how they plan to be more proactive in addressing the serious problems the data identifies. We will also hear directly from the Board of Correction, the jail oversight body that both monitors the grievance process itself and also works independently to ensure minimum standards are met. If the true goal of this and previous administrations was to reduce violence and ensure people do not leave city custody worse than when they enter it, we are failing to not only meet that goal, but demonstrate a concerted effort to get there. In design and practice, the DOC's grievance process leaves many vulnerable individuals who have not been convicted of a crime to suffer in an isolated environment without an adequate opportunity to have their voice heard. Today's hearing is about demanding accountability from the people in charge and learning about their concrete plans to change this paradigm. I do want to warn listeners that we will be touching upon topics of sexual assault and abuse, so please take care as needed. I will now ask our committee counsel to swear in the first panel of administration witnesses, and I will read the names. So I will now introduce our first panel of administration witnesses and ask the committee counsel to swear them in. With us today we have Sharian Rembert, Assistant Chief of Administration, James Saunders, Deputy Commissioner of Health Affairs, Jonathan Levine, Assistant Commissioner of Special Investigations, Michelle Stafford, Executive Director of the Office of Constituent and Grievance Services, Nancy Savasta, Acting General Counsel, there you are, okay. From CHS, we have Jeanette Merrill, Assistant Vice President, Communications and External Affairs of H&H CHS. And I'll turn it over to you now.
Thank you. If you could all please raise your right hands. Do you affirm to tell the truth, the whole truth, and nothing but the truth before this committee and respond honestly to council member questions? Noting for the record that all witnesses answered affirmatively, you may begin your testimony.
Good morning, Chair Nurse and members of the Committee on Criminal Justice. I am Sharian Rembert, Assistant Chief at the New York City Department of Correction. I am here today with my colleagues to discuss the department's complaint and grievance procedures and the work that is underway to enhance and improve this vital system. We recognize that a transparent grievance process and timely and meaningful resolution of complaints reinforces a safe and humane environment for all. For several years, the department has strived to improve the grievance process by using technology, innovation, and streamlining procedures. We remain committed to these efforts. It is our goal to make the grievance process as accessible and clear as possible in order for people in our custody to know they have a meaningful avenue to have complaints heard and addressed. Individuals in the department's care have multiple avenues to submit a complaint to DOC, including calling 311, placing complaint forms in grievance boxes distributed throughout the facility, and speaking directly with departmental staff. In addition, complaints can be submitted directly to the Board of Correction, the Department of Investigation, and other oversight and investigative bodies. The grievance process, including how to submit a complaint, is outlined on posters throughout facilities and in the individual in custody handbook, which is distributed to all people in custody upon intake and made available on the tablets. Complaints that are submitted to DOC are managed by the Department Office of Constituent and Grievance Services, referred to as OCGS. OCGS triages, tracks, follow up on individual complaints, and report complaints trends to departmental leadership to ensure systematic issues can be identified and addressed. A team of dedicated OCGS staff tour the facilities regularly to make people in custody aware of the grievance process, replenish complaint forms, collect forms left in grievance boxes, and discuss and investigate complaints that are filed. Members of the public and other third parties can also submit a complaint on behalf of a person in custody by calling 311 or submitting a grievance form. A centralized team of OCGS staff manage the information phone line and inbox, as well as complaints routed from 311, and ensure that all complaints submitted to the department are properly recorded in a centralized database and monitored until resolution. The department categorizes complaints in one of three different ways to determine how the complaint will be managed: grievable, non-grievable, or rejected. Grievable complaints are related to conditions of confinement and subsequently addressed by OCGS staff or staff from other units that are based in the facilities. These include complaints related to clothing, law library, or commissary, to name a few. OCGS staff will work with people in custody to address complaints related to missing items such as linen or toiletries, complaints related to identified services such as religion, program, and visitation will be tasked out to unit or command that oversees the operation for resolution. Grievable issues are expected to be resolved expeditiously. OCGS tracks all complaints for their life cycle and will send out reminders to command leadership or otherwise escalate as needed until the complaint has been addressed and subsequently closed out. Once a grievable complaint has been closed out, it is assigned an outcome status, and the person in custody is notified of the outcome. Non-grievable complaints typically involve an allegation that must undergo an administrative investigative process. Complaints are related to condition of confinement that cannot be immediately addressed by OCGS. This includes complaints related to fear for safety, assault, medical or mental health care, and disability accommodations, to name a few. Complaints that are non-grievable are forwarded to the appropriate unit or provided partners for future investigation and resolution. OCGS continues to track the life cycle of these complaints and is notified when they are addressed, but is not made aware of the detail or contents of the investigation. Because OCGS does not manage the investigation or resolution for these matters, OCGS does not provide an outcome status to the person in custody who filed the complaint. People in custody must be notified of the outcome of the complaint by the unit that manages the complaint, depending on the matter. Complaints that pertains to matters that the department cannot provide a response to, such as a complaint about New York State prisons, external institutions, or a complaint that does not contain enough information to process further, are rejected. If a grievable complaint made by a person in custody is rejected, OCGS staff will notify the individual as to the reason the complaint was rejected so that the matter is addressed, or for them to file the complaint with the applicable entity. If a non-grievable complaint is rejected, the person in custody typically would not be notified, either because the complaint does not have enough information to identify the complainant, or because the complaint is outside the scope of the department's work. Grievable complaints managed directly by OCGS staff can be appealed if an individual in custody is not satisfied with the outcome. Information on how to appeal a grievance outcome is provided on the disposition returned to the person in custody with the grievance outcome. As a first step in the process, people in custody may request that the evidence submitted to support the outcome of their complaint be reviewed by a facility or unit's commanding officer. Upon review, the commanding officer will either affirm the original outcome or provide a different outcome. If the person in custody is still not satisfied with the resolution, they can appeal to the Central Office Review Committee, which is comprised of individuals who are not involved in the initial investigation or resolution processes, and includes the executive director of OCGS, a uniform leader, a non-uniform leader, and a representative from the department's legal division. At this stage, an independent investigation is conducted by the committee utilizing all evidence, statements, and documents gathered, and a final disposition is provided to the person in custody. This disposition is final and cannot be appealed further. Grievable complaints that are not investigated and addressed by OCGS staff cannot be appealed. However, if OCGS observes continued complaints about a grievable issue tasked out to another unit, they will reach out to the unit leadership to alert them in order for the unit to work towards a resolution. Non-grievable issues cannot be appealed through OCGS, as they are governed by regulation and procedures that fall outside the scope of OCGS's work, such as use of force and/or PREA-related matters. The work of OCGS is critical to ensure that our jails remain safe and humane, and the department is continuously exploring ways to leverage complaint data and improve the complaint and grievance process. OCGS utilizes data to inform department leadership about emerging issues and to drive operational change in areas that can be improved. Reports that capture the rate of incoming complaints and trends in top complaint categories are shared with facility and unit leadership daily so that systematic issues can be identified early and strategically addressed. When facilities are newly commissioned or a new initiative has been implemented, OCGS provides a recurring 30-day complaint trend report to aid leadership and making any needed changes to operation. OCGS also engages in heightened monitoring and reporting during inclement weather and other emergency events that may impact facility operation and people in the department's care to ensure issues that may impact health or safety can be identified and addressed quickly. In January of this year, the department launched a public platform on its site that allows members of the public to check the status or outcome of a complaint they have submitted. On the heels of this initiative, the department is actively working to develop an application that will allow people in custody to submit grievance via tablets to increase access to the grievance process. We anticipate launching this new application in the summer of this year. The goal of the complaint and the grievance processes is to provide a greater voice and support for those in our care so that everyone who lives and works in the jails can return home to their families and communities safely. We appreciate the Council's interest in supporting this very important work, and thank you for the opportunity to testify today. My colleagues and I are happy to answer any questions you may have.
Good morning, Chair Nurse and Councilmember Caban. I am Jeanette Merrill, Assistant Vice President of Communications and External Affairs for New York City Health and Hospitals Correctional Health Services, also known as CHS. I appreciate the opportunity to speak about CHS's processes for addressing patient complaints about the health care provided in the jails. CHS was established in 2016 as a new division of New York City Health and Hospitals in order to provide high-quality health care to people in the custody of the Department of Correction, not as a contracted service, but as the direct provider of care. To provide a sense of volume within our service, last calendar year, CHS provided or facilitated more than 433,600 scheduled health services to more than 26,000 patients. This includes approximately 223,000 nursing appointments, 18,800 medicine appointments, 105,600 mental health appointments, 42,400 reentry service appointments, 9,000 dental appointments, 15,500 substance use appointments, 15,500 on-island specialty services appointments, and 3,700 off-island specialty services appointments. Additionally, more than 20,000 clinical intakes were conducted at the point of admission, and there were 50,000 referred visits. CHS also provides non-scheduled health services, including injury evaluations. In addition to increasing the breadth and quality of health care provided in the jails, CHS has endeavored to improve the communication with people in custody, our patients, concerning the health services we provide. We encourage our patients to discuss their healthcare concerns, complaints, and requests directly with their providers during clinical encounters. However, we also recognize the importance of maintaining other pathways for patients to communicate their needs and concerns. Accordingly, CHS developed and implemented in early 2020 the CHS Health Triage Line to enable our patients to contact CHS directly about their non-emergency health concerns. Using their tablets or the phones in their housing areas, patients can call the Health Triage Line to speak directly and confidentially with a CHS nurse or during off hours to leave a voicemail, all of which are reviewed and appropriately handled. Last calendar year, patients made 48,622 calls to the Health Triage Line, 90% of which were answered live. 63% of the total calls resulted in the triage nurse scheduling a clinic appointment for the patient, and 37% of the calls were handled administratively. If the patient calls to share a complaint or concern about the healthcare services received in custody, CHS's Patient Relations Department will manage the inquiry. CHS Patient Relations manages requests and complaints from patients, family members, attorneys, and other external parties relating to the healthcare CHS provides. The Patient Relations team receives these inquiries via email or phone and then determines whether the inquiry is a request for services or a complaint about services provided. Last calendar year, CHS Patient Relations received 12,998 inquiries, including 5,361 requests for health services, 4,643 complaints about health services, and 2,994 requests and complaints concerning DOC, which Patient Relations sends to DOC to address. If the inquiry concerns a request for health services, Patient Relations contacts the clinic in the facility where the patient is housed in order to process the request. If the inquiry concerns a complaint about health services, Patient Relations assigns the case to one of its registered nurse RN investigators. Regarding the largest categories of healthcare complaints that Patient Relations received last calendar year, 36% concerned medication, 33% concerned access to care, and 20% concerned quality of care. The 4,643 complaints were made by 2,803 unique individuals. After reviewing the patient's medical chart and relevant CHS policies, the RN investigator sends a preliminary case summary to the clinical and operations teams in the relevant facility to review and to provide feedback and next steps within 48 hours. The RN investigator follows up with the clinical team to ensure CHS has addressed the patient's concerns and to compile a preliminary investigation determination. Following the investigation, preliminarily confirmed complaints are reviewed during Patient Relations monthly Quality Improvement Committee meetings to make a final determination. During these meetings, an interdisciplinary team that includes staff from medicine, nursing, mental health, pharmacy, and operations reviews the claim, the investigative findings, and the preliminary determination. Examples of recent confirmed complaints include a patient who experienced a delay in receiving eyeglasses because the vendor did not send the order, and a patient who did not receive Tylenol despite it being referenced as part of the plan of care because the provider did not submit the medication during the injury encounter. Last calendar year, less than 1% of the 4,643 complaints about health services were clinically determined to be valid, meaning that the vast majority of complaints were not supported after review of the medical record and of the effect on the patient's care. For example, a patient recently issued a complaint that CHS had denied him access to dental services, but during the investigation process, the RN determined that there was an active referral for dental services in the patient's health record, and the appointment was scheduled within the appropriate time frame. Therefore, the complaint was deemed unconfirmed. Regardless of whether the patient relations team confirms the clinical validity of the complaint, CHS works to address every patient's complaint or concern at the facility level. Each investigation is used to identify opportunities for improvement within CHS. We recognize we have a profound responsibility and opportunity to care for some of the most marginalized New Yorkers while they're in the city's custody, and CHS is committed to continuing to find ways to improve the quality of the healthcare we provide. The mission-driven professionals who work for CHS work each day on behalf of our patients to provide a community standard of care despite the challenges and restrictions of a jail environment. Thank you.
Thank you. I want to recognize Councilmember Shahana Hanif is on Zoom. We've been joined by Councilmember Tiffany Caban. So thank you for your testimony today. And we've been joined by Councilmember Chris Marte. So I'm going to start just with some line of questionings around the procedures themselves and then the data. So I wanted to start with a yes or no question. Is everyone in custody who raises an issue by filing a grievance form or by calling 311 entitled to a response from DOC?
Good morning. I'm Dr. Michelle Stafford, the Executive Director of the Office of Constituent and Grievance Services. Yes, all persons in our care have access.
Thank you. And the response to that grievance is people are supposed to get a 7102R, the formal resolution disposition form. Is that right?
Correct. They have the forms in their housing areas, and once a disposition, if grievable, is provided, they do receive a disposition.
Okay. So according to the directive, everyone who files a grievance is entitled this formal resolution to address their concern, but the reporting that we get and that is provided to the council should show that an equal number of grievances filed is equal to the number of formal resolutions, but that's not really the case in the reporting. So what percentage of grievances receive a formal resolution?
All complaints that are grievable and investigated directly by OCGS staff do receive a formal resolution.
Okay.
Complaints per our policy at this time that are non-grievable do not receive a resolution. We are actively working to provide access to persons in our care where they can receive a resolution.
Okay. According to the analysis done by our data team, less than 15% of grievances filed within the past 4 years were resolved at the formal level with this formal resolution. And in fact, in your report that covered January through March of this year, there were 9,148 grievances filed, and exactly 1 grievance was resolved at the formal level. So off the bat, it's showing me that there's some kind of breakdown here in the system.
Yes, so all grievable complaints where persons in custody wish to appeal, they can go through that process. That's the only time they would continue to appeal through that formal process. Oftentimes, persons in custody do not continue to appeal.
So you're saying that if, I'm not talking about an appeal.
Right.
Even just, I filed a grievance.
Yes.
Am I entitled to get a 7102, some kind of response, a formal resolution?
If the matter is grievable and investigated by OCGS staff, yes, they will receive a disposition. If it is non-grievable per the directive, at this time we do not provide a response. If the matter is addressed by an internal unit, which is non-grievable, they may not necessarily receive a disposition, but action will be provided.
Okay. So as I'm understanding, grievances cannot be filed electronically on tablets, and we've heard repeatedly that calls to 311 often trigger no action. So the other option that folks have is filling out the grievance form, 7101R, and dropping it into a grievance box. And we see most of the complaints coming in from 311 calls, which maybe indicates there's potentially a lack of access to grievance boxes, or maybe there's an issue, other issues there. So as of today, is there a grievance box in every housing facility on Rikers Island?
I'd like to back up at this time. If a grievable complaint is received electronically via 311, that complaint is tasked to OCGS staff and it is addressed within policy. There are 50 grievance boxes across the facilities that are in targeted common areas such as the corridor, law library, programs, and the clinic.
So it's your testimony today that every housing facility has a grievance box?
I will not say every housing area. They're in targeted common areas. In the facilities, there are 50 boxes.
Okay, so we've heard there are no grievance boxes in NIC or West facility. Can you confirm if those are there or not?
I can confirm that there are grievance boxes in the West facility, and there are grievance boxes in the targeted common areas in the NIC.
Okay. Okay, so a grievance box is installed in what you're saying is targeted common areas, but we've also heard that some folks have really had challenges accessing the box because they're sometimes located where people might not really have the ability to visit on a regular basis. So how do you make sure grievance boxes are accessible to people in custody?
It is our goal to ensure that persons in custody have access to the grievance process. OCGS staff tour housing areas 2 to 3 times a week to meet directly with persons in custody. At that time, they can receive the actual paper complaint from the person in custody, and they're also reviewing the boxes.
Great. And, you know, access is super important since a grievance has to be filed within 10 business days from the date of the incident.
Absolutely. Thank you.
Right. So is the grievance form 7101R, that one that in actual grievance boxes, is that are available on site, is that available in multiple languages on site?
Yes, it is. It is available.
So if I go to how many languages are in those are
So
available?
I believe there are 13 languages.
Okay.
However, the languages that are readily available in the housing area are both in English and in Spanish. If another language is required, the person in custody can simply ask OCGS staff. And we work with internal units to determine which language is required.
Okay. And if someone has a disability, who do they ask to help fill out the form? How do they contact someone?
So persons in custody, again, when OCGS staff are doing their tours, which they do 2 to 3 times a week, they can speak directly to the OCGS staff member or to the officer on post, and we will work with them accordingly.
And can you confirm that at least 3 times per week OCGS staff are visiting punitive segregation, hospital wards, mental observation units, and other special housing areas where a detainee perhaps cannot directly access the grievance box?
The department does not operate punitive segregation housing areas. General housing areas will receive a tour from a grievance worker 2 to 3 times a week. The specialized housing areas will receive 3 for sure by OCGS staff.
Okay,
And this
just for
is tracked.
clarification.
I'm sorry.
Just for clarification,
Yes.
so for punitive segregation areas, you saying their tours are not happening for OCGS staff?
The department does not have any housing areas identified for punitive segregation.
Okay. Since most of the complaints come through 311, it's important to have access to the phone or a working tablet. We've heard reports from legal service providers that the phone system, whether it's landlines in housing areas or other phone applications on an individual's tablet, is often arbitrarily shut down so that no calls can be placed. Not only does this limit the ability of people in custody to call 311, but also to call family members or request urgent medical attention from CHS. In particular, we've heard this frequently happens during lockdowns, which strips people of the opportunity to lodge complaints about deprivations caused by lockdown. So in what specific circumstances and what is the justification for the department deciding to shut down phone access at certain times?
Persons in custody are able to place complaints within departmental policy. The grievance forms are available during the lockdown, which is in the housing areas. However, once the lockdown is lifted, they are able to utilize the phones in the housing area and the tablets. I will defer this question to Assistant Chief Rembert.
But just really quickly, so during lockdown, you're saying folks can access the grievance box?
If they're in a dormitory setting, yes.
Good morning, Assistant Chief Rembert. Can you repeat your question as far as the lockdown portion?
Yes.
Please.
So, access to the phones, very
Yes, ma'am.
important. It's where most people are making their complaints because most complaints are going through 311. So we've heard that they're losing access to phones during lockdowns, particularly during lockdowns. So in what specific circumstances and what is the justification for the department to shut down phones or phone access during lockdowns?
If there's an incident that had transpired in the facilities and we need to conduct an investigation or search, the phones are shut down for safety and security. As soon as it's completed, then the phones will be lifted for them to use their tablets or the phones. In addition, their phones the tablets are not in use during lock-in. It's scheduled lock-in, which is at nighttime.
And so on average, what would you say an average lockdown time period is?
I do not have that response at this time to give you the data on that, but I will circle back with you.
Okay, would love that follow-up.
Yes, ma'am.
Okay, so going back to the resolution of grievances, given how the data is showing that less than 15% of grievances filed receive a formal resolution, I want to understand what it means when your reporting shows the overwhelming majority of the grievances filed are deemed accepted. For instance, in the third quarter of FY24, nearly 70% of grievances filed were considered accepted. In your directive, there is a definition of when a grievance is considered accepted. It's on page 7. And if you have access to it, would you read the definition for the record?
I don't have access to it at this point.
Okay, I have it for you. So the definition of an accepted grievance filed in Directive 3376R, accepted means is used when the complaint is being handled by the grievance coordinator or tasked to any unit/facility. This does not validate whether a complaint is substantiated or unsubstantiated. Selecting this field also confirms an inmate's requested action is met. So based on this definition, can you explain how the term accepted can be used to describe both when a grievance is being handled and when it's been resolved? So as an example, if someone's not getting clean clothes and they filed a complaint and it gets categorized as accepted, what am I to understand about the status or outcome of that complaint?
So when a complaint is deemed accepted, it means that it falls within the purview of the department, and we can investigate the department, whether that's by OCGF staff if it's a grievable matter, if it's by an internal unit, grievable but tasked and or assigned out, and non-grievable, meaning that it's going to go under another administrative process. Rejected complaints or complaints that do not fall within the department's scope or fall under external agencies or are part of a return of grievance, a duplicative complaint. So that's.
Well, you can see how the definition of the word is, so the way this is described in the terminology from the handbook or from this directive, you can see it's pretty broad. So, we're looking at the data and we're saying accepted, again, is used when a complaint is being handled by the grievance coordinator and or tasked to any unit/facility, does not validate whether a complaint is substantiated or unsubstantiated, and selecting this field also confirms an inmate's requested action is met. So it's not clear if it's resolved, if they got, in the example I brought out, did they get clean clothes? Did they not get clean clothes?
Yes, I can see how.
Yeah, so it would be really helpful if maybe we could work together to resolve that terminology and that definition, because, right now there's no way of knowing, what the status of these complaints are or if they were adequately resolved. And we don't know if people, we hear complaints all the time. People aren't getting medicine, they're not getting food, they're not getting their clothes, there's heating issues, there's whatever's going on. And this terminology does not lend itself to understand what the conclusion of these outcomes are.
Thank you. So we're actively reviewing our policies, and when it's finalized, we're more than happy to follow up.
Okay. So what percentage of dismissed or closed grievances are related to a grievance that was filed too late or not signed?
I don't have that data with me. However, I'm sorry, can you ask that question again?
So, there's a time frame in which
Correct.
people have to submit this file, the 710, the
Within 10
71,
days
yeah,
of the
or the
incident,
grievance
correct.
form within 10 days. How many times what is the percentage of those grievances filed that are dismissed because they were filed out of the time period, or they weren't signed, or there was something wrong with the
So
form?
OCGF staff make every effort to ensure that the dispositions are signed. And so I would say it's a small percentage. I don't have that data with me. However, the data that you are reviewing does not include complaints that were rejected. So it's only accepted matters.
No, I know, that's why I was asking it out of.
It's a small percentage. I don't have that with me.
Okay, I'd love to request that in the follow-up. Okay, in an instance when a grievance is filed through 311, and this is my question because I was really trying to understand the logistics of the procedures of getting this form filled out. So if someone fills out the form or files a grievance via 311, my understanding is it has to be signed. Or even if someone files on behalf of someone, it has to be signed. Is that right?
So persons in custody, if it's placed through the grievance box, yes, it has to be signed. If a grievable complaint is received electronically and being addressed by grievance staff, they will take the grievable electronic complaint, transfer it to an internal form that we created, and then go in the line with the person in custody in which they would sign.
And so my understanding from reading the directive is that the employee that goes to the person affected must be a grievance coordinator. Is that correct?
That is correct.
Okay. Are there times, or is it a common practice for correction officers to walk that form to the person affected?
That I don't have knowledge of that. However, OCGF staff do ensure that these forms are signed by persons in custody. We manage our own paperwork.
Okay. So it's your testimony that you're not sure if, in the instance of bringing this physical form to someone, a person affected, that it's always the case that it's a grievance coordinator. You're not sure that.
It is always it's my understanding that it's OCGS staff that are having the form signed
Okay.
from the person in custody.
And so just to continue to clarify, a grievance coordinator, there's grievance coordinators and then there's grievance officers.
Correct.
And the only person in the directive on the policy is that can bring that form and communicate with that person who is affected is the coordinator. But what you're saying is general staff may be the one doing that.
OCGF staff, correct.
Okay. Do you believe if a correction officer is perhaps, maybe there's a staffing issue for the day, perhaps a CEO goes and brings it, do you believe that it would create a situation where retaliation could occur or grievance might be not moved along further into the process?
OCGS has both uniform and non-uniform staff, so we make every effort to ensure that OCGF staff are serving or providing the disposition. So that's all that I can speak to at this time.
Okay. If a person files a grievance and the grievance coordinator proposes a solution that a person in custody does not agree with, or if the grievance coordinator dismisses the complaint, there are supposed to be 3 additional layers of appeal. The first is to appeal to the decision to the commanding officer. After that, an appeal goes to the division chief, and finally to the Central Office Review Committee. Back in 2019, when this committee held a hearing on the grievance process, one of the recommendations made by the Board of Correction and other advocates was that DOC simplify the grievances process. And in testimony, BOC said that from start to finish, the appeal process can take more than 10 weeks to complete. What is the rationale for having 3 layers of appeal before a person is giving a final determination about their grievance?
It is our goal to ensure that we do a thorough investigation for all complaints that we receive. When the complaints go through the appeal process, we believe that it affords an opportunity for each level to conduct an independent investigation where more evidence can be provided in hopes to either substantiate or unsubstantiate whatever their matter is. That's why it would take such time.
Okay. And then it seems like after that hearing, there was an additional layer added in. Instead of simplifying it and streamlining it, there was an additional layer, the preliminary evidentiary review, which seems to make the process a little more complicated for people in custody. Is there a reason for adding that additional layer?
That additional layer is only utilized if the OCGF staff member identifies that they would like for it to be reviewed. At this time, we have a small percentage that actually utilize that option, as we hope to provide a speedy response to the person in custody.
Okay, if in the follow-up you could let us know what that percentage is, that would be really helpful. Okay, the grievance directive does not really say how many days a detainee has to file an appeal to the commanding officer. Why is that? What is DOC's recommendation, and when will it give a clear timeline in the directive?
We are actively reviewing the policy to see how we can enhance how we provide a response and a speedy response to persons in custody. Internally, we have worked to create a 5-day turnaround time for persons in custody to either support whether they're in the housing areas at the time when we come, or to give ourselves time to make sure that we're providing a response. So that's what.
Okay. Has DOC eliminated the second layer of appeal that goes to the division chief?
Yes, we have.
Okay, that's great. When will that be reflected in policy?
We're currently reviewing it, and
Okay.
once the policy is.
It sounds like you're doing a big review here of the grievance policy.
It's our goal to make sure we're
Do you have
transparent.
no, I understand, but do you have a sense of timeline on when this process is going to be?
Well, we're actively reviewing the policy and how we report out our data, and once it is available, we will provide it.
Okay. No, I understand. I've heard that it's an active process, just trying to understand if there's a timeline here. Having a cumbersome grievance process obviously creates serious consequences in terms of access to the justice system. After the passage of the Prison Litigation Reform Act in 1996, a detained person can not have federal civil rights violations redressed in court unless all administrative remedies are first exhausted. To your knowledge, how many times has the law department used non-exhaustion of administrative remedies as a rationale to dismiss lawsuits filed by people in custody?
I am unable to provide that answer. However, I would defer to Assistant Chief Rembert.
Okay. And we sent these over on Monday?
Yeah.
Okay. So we sent these over on Monday. I know it's not the fastest turnaround. I understand Monday morning, but there's a lot of people work at DOC, and it would be great in the future even if you just give us X amount of days you need ahead of time and prep for the meeting, because I know we sent these questions over, and I think it's a pretty simple set of questions.
Yes, ma'am. I'm going to defer it to, I'm sorry, Sherry Ann Rimberg, Assistant Chief. I'm going to defer it to our General Counsel.
Okay, thank you.
Thank you, ma'am. Yes, Nancy Savesta, Acting General Counsel for the Department of Correction. That information is actually not in the possession of the Department of Correction, and we would have to defer to the New York City Law Department for that information.
Okay, helpful, thank you. I'm going to move into, I just have a couple more questions around the data, and then I'm going to touch upon sexual assault. And then I'm going to open it up to other council members. Okay, so just a couple quick questions around compliance reporting, compliance with data reporting. So the council passed a local law in 2019, which mandated that all complaints and requests made on behalf of a detained individual get addressed by the Office of Constituent and Grievance Services. We have heard directly from legal service providers that there remains no process for a third-party complaint to be handled through the grievance process. So beyond the assignment of an index number, legal providers who file a grievance on behalf of their clients get no indication that it's been integrated into the grievance system, and they are never presented with a proposed resolution or opportunity to appeal a resolution. Is there a reason the department appears to be out of compliance with this local law?
Anyone can place a complaint about a person in custody on behalf of the person in custody using 311 or other avenues. The department recently implemented a complaint status system in January of this year where anyone, the public, can follow up on the status of their complaint or the outcome of their complaint.
Okay, great. But there's no, I get that it's a publicly available database, but there's no actual process for if, for example, a legal service provider that's representing someone or supporting someone files a complaint on behalf, they get the index number, but there's no mechanism within your system that lets them know an outcome or resolution of the case?
They may utilize the index number that they receive to go through the department's website where our complaint status system is housed to find the status or the outcome of the complaint.
And that's the January, the publicly made
Correct.
available one just this January?
Yes.
Great. Okay. Another local law passed in 2019, sponsored by Deputy Speaker Ayala, created robust quarterly reporting requirements regarding how many grievances are filed and the various ways they get resolved. However, there are some pretty crucial data points required by the law that are missing. So for non-grievable complaints, which include serious accusations like sexual assault and abuse, the law requires reporting on where those complaints are referred. That is currently not being reported. The law also requires reporting on the number of people in custody who submitted grievances. This information would be helpful in understanding how many individuals are filing multiple grievances. When will this issue be resolved in order to bring DOC in compliance with the law?
So we are aware of the reporting structure at this time. We've realized that there are some adjustments that need to be made to the report. It's important to note that the operation and the data has evolved since the grievance, since 2019, and we're actively working to address the reports.
Okay. The charter also mandates that you provide this report and every other DOC report in a machine-readable format, like a spreadsheet. And, you know, I think the council has repeatedly asked for these reports to be not PDFs. I mean, these are numbers, and in a PDF, obviously, if anybody's ever copied and pasted from a PDF into anything knows it's actually pretty hellish. So, you know, can you commit to sending these reports in a spreadsheet? It would save us time. It's really burdensome for the staff we have here, the data teams that we have here to go through all that. Can you commit today to providing a machine-readable format like a spreadsheet?
OCGS will provide the data accordingly to our InterGov team, and they will work with you guys accordingly.
Okay, so you can't commit to providing a spreadsheet?
We can provide a spreadsheet.
That would be really helpful. Thank you. And to be fair, our transcripts for these hearings are in PDF. So it's like the PDF is a nightmare for everybody in all fronts. So not necessarily just picking on you. Okay. I'm going to move on to sexual assault complaints. So last month, the news outlet Gothamist published a pretty extensive report that analyzed cases brought under the Adult Survivors Act and found that nearly 60% of the civil lawsuits in New York City state Supreme Courts were filed by people who alleged that they were sexually abused while in custody at Rikers Island. The 719 lawsuits include allegations of DOC staff groping people in custody, coercing them to engage in sex acts, and acts of rape. And I just want to read the opening of that article to kind of bring the gravity of these allegations fully into the room. And I understand that they are allegations and there's a potential investigation underway. Jenny remembers, this is a quote, Jenny remembers trying to hide under the rough, jail-issued seats when the Rikers Island guards would come for her in the middle of the night. She said she called out the names and ID numbers of women in the room, where she slept on a makeshift pillow of bundled clothing. Then she said the correction officers ordered the women to rise from their beds before leading them down a series of long hallways in silence. Quote, "We just had to be kind of like soldiers, walking to where they were leading us," she said. Quote, "Once we passed through a door, everything was pitch black. Jenny said the officers took the women to a dark room with benches, which was illuminated only by the occasional glow of a flashlight. They ordered the women to kneel and be quiet before forcing them to perform oral sex, she said, unquote. The details of these allegations are pretty horrific, and many of the lawsuits claim that jail officials knew or should have known that these sexual allegations and assaults were occurring on their watch. This is why we're having this hearing, and this is why opportunities to safely file a grievance is so important. Pursuant to guidelines established in the Prison Rape Elimination Act, or PREA, and adopted as BOC minimum standards, the department is supposed to complete a semi-annual report to evaluate sexual abuse and sexual harassment allegations made within the past 6 months. And I want to look at the data you produced in the last PREA report and compare it to what was reported in your quarterly reports on filed grievances. And I'm going to read slowly because it's dense numbers. So in the PREA reports from July 2022 to December 2022, you listed 132 allegations of sexual abuse and harassment from people in custody. While over the same 6-month time period, in quarterly grievance reports, you stated that there were 682 grievances filed with a sexual assault or sexual abuse allegation. From January 2023 to June 2023, PREA reports state that there were 114 allegations of sexual assault or sexual harassment, while grievance reports during the same time indicate there were 701 grievances filed with allegations of sexual abuse or sexual assault. So can you try and explain this discrepancy where the number of allegations of sexual assault and abuse that you list on the PREA reports is significantly lower than the number of grievances filed on this issue?
I'd like to start by saying we take these matters seriously. When OCGS receives complaints of such nature of sexual misconduct, we task out the complaint to the Special Investigation Unit, in which I will defer to AC Levine, who oversees this.
Thank you.
Good morning, council members. Jonathan Levine, I'm the Assistant Commissioner, PREA for the New York City Department of Correction. And let me chime in on what Dr. Stafford just said. We share your concern that the jails should be safe, and any form of behavior involving sexual misconduct, sexual harassment, and sexual abuse is unacceptable. And getting back to, just repeat the question. I want to make sure I give a firm answer on that.
I'll try to summarize it. In the PREA reports, there's 2 different 6-month periods we looked at. You're having significantly lower allegations than what is in the reports on your grievances filed, almost like 500 per term that we're looking at, a difference, where sexual abuse or sexual assault are both in there.
Yeah. Yes. Thank you for clarifying the question for me. What Dr. Stafford gives us, if I can go into the process slightly.
Please.
Dr. Stafford gets 311 calls and sends it to my PREA investigation team as what they refer to as task IDs. Those task IDs are allegations made by persons in custody, whether they be against staff or whether they be against other persons in custody. The other number that you quoted was from the Board of Correction report, the 540 report. Am I correct? Is that what you're looking at?
Yes.
The Board of Correction 540 report documents the PREA reportable cases. PREA reportable cases there's a difference between a PREA reportable case and an allegation. This was the total number of allegations that Dr. Stafford staff referred to my investigative team, and through our investigation, that the number that you gave us was the number that falls into the category of being PREA reportable, and those allegations have to meet certain criteria. Doesn't mean that we do not investigate them, and that's why I wanted to bring this back a little bit and let you know that every single complaint that comes to my office is taken seriously and it does get investigated. The categorization of PREA reportable versus PREA non-reportable is a difference, and there's a difference between the number of allegations we get as referred to PREA reportable and PREA non-reportable. And just for your clarification, anything in Penal Law 130, sex crimes, would be PREA reportable. Anytime we have a person in custody going in and going to a hospital where a sexual assault evidence collection kit is prepared, PREA reportable. Person retaliation, any form of retaliation, PREA reportable, or repeated sexual harassment. Those are the categories of PREA reportable. Doesn't mean there are other things that we have as called PREA non-reportable. Those allegations do get investigated. They are taken seriously, but those are not categorized on the Board of Correction report.
Okay. I understand that you're saying there's a threshold for the PREA reporting.
Correct. That threshold is established in the PREA federal standards, yes.
I mean, it's hard to think about it in just like a basic definition. I guess I'm just trying to understand the level of threshold that one would just remain on a grievances filed report and one would be up. And I'll have to spend some time understanding that a little bit more, but thank you for clarifying the process. It's still quite a number of complaints. And like I said, even the 2 6-month periods that we looked at, we're talking about almost 500 reports differential. So it just feels like a stretch that that many 500 would not be reaching a threshold.
Well, if I can just reiterate that we do take every one of the complaints seriously, and they do get fully investigated.
Okay. Okay, a few more questions, and then I'm going to open it up to my colleagues. Are all allegations of sexual abuse or sexual assault being referred to the investigation division? Are all allegations of sexual abuse or sexual assault being referred to the investigation division?
Yes, they do come through. They do come to my investigative unit, but they don't only come through 311. We have multiple ways an individual in custody. We employ many ways that they can make any of these allegations. 311 is our most prevalent form, over 80%. We do get referrals from our partners in CHS. We do get them from many legal services, attorneys, defender services. We also get them from other correctional facilities or other law enforcement, because when somebody may outcry when they go to state prison, federal, any of the other institutions. So we do get on a regular basis outcries from persons that those would be in the past. But we do, those are the sources we get. We also get third party. We have people who call us up as third
So
party.
you're getting a lot from incoming, and they are being referred to you.
Yes, they are.
Thank you. Can you just say how many current pending investigations in ID that are related to allegations of sexual assault by a staff member?
I don't have that for
Okay.
this. What time period are you looking for?
Current pending.
I don't have that information with
Okay.
me, but I'd be glad to get back to you.
I would
Let me
love
get
the
that.
follow-up on that.
Yes, I could.
Thank you. Just want to touch briefly, I know the Bronx District Attorney's Office has said that they are, they've assembled a team of prosecutors to start reviewing these allegations. Have you started working with that office at all? Have they reached out to you?
We reach out to the Bronx District Attorney's Office on a daily basis. There is a Rikers Island Prosecution Bureau that's based on Rikers Island. We have a dedicated
But are you,
sexual
on
assault-
this issue, are you all starting to collaborate or work together?
She has reached out to our office for certain individual cases, yes.
Okay. Can you let us know how you all are working? Can you let us know how you are working with the office already?
Very well. I just don't We have a very good, I have, and my staff has a very good relationship with the Bronx District Attorney's Office, and we cooperate fully in anything they need.
Okay.
We will assist them.
Okay. So just this morning, the Gothamist published another article detailing a pattern of sexual assault allegations made against jail medical staff. They report that most of the women who filed lawsuits against medical staff say they were assaulted during examinations, including during health screening and physical examination when a person arrives at Rikers Island. So I do have a couple of questions for CHS, and then I'll move on. But would it be typical for a health screening at intake to include an examination of a person's breast or genitalia?
Thank you. So part of intake is to conduct a health screening. They meet with nursing, they meet with medicine, potentially mental health, but we're really trying to gather basic information as you would, at a first visit at a doctor's office. If it were clinically indicated that a patient required a breast exam, anything involving a private area, that would be a follow-up appointment. That wouldn't be conducted during the medical intake process. And I should note as well, at Rosie's, there's a chaperone policy in place. So there should always be a second staff member present outside of emergency medical evaluations. And if there isn't staffing that day, then it would be rescheduled to the appointment.
Okay. In one of those allegations, it was reported that a chaperone was present during that. So what training do chaperones receive to ensure they're acting as an adequate prevention tool in reporting abusive behavior?
Yeah, I should say all of our staff receive PREA training. It's required of all new employees, and then every 2 years. So we are mandated reporters under PREA. So any allegation or knowledge or reasonable belief that there has been a sexual assault, harassment, abuse, we do report that, and then that goes to the department. We don't engage in the investigation, but all of those cases are reported. If it is against CHS staff, it is also reported to the New York City Department of Investigation, as well as the New York City Health and Hospitals Inspector General's office. We also have multiple pathways for, as I mentioned in my testimony, for patients to communicate any concern to us.
Okay. And just taking this one story, this one example in this story, I'm not asking you to comment specifically on this allegation, but using as an example, this is a woman who alleged that a chaperone was present when they were sexually assaulted during a medical exam. They filed a grievance, but no one followed up with her. So this is a case that predates, obviously, this administration, but in a situation like that, what is being done to ensure between CHS and the PREA unit within the department's investigations division, an allegation like this is taken seriously, investigated thoroughly, and if substantiated, people are held accountable? And how is it communicated back to an affected person that a process is happening and there has been an outcome?
Yeah, so I would just start by saying, well, as you mentioned, I can't speak to what happened under Horizon. The article itself is very difficult to read, and when a medical provider abuses a patient, it is especially egregious. So we do have these policies and practices in place to protect our patients. So in an instance like that, when a complaint is filed, the patient should be brought to the clinic for an evaluation. They would receive referrals to mental health, additional medical care. If there's trauma, in consultation with our emergency physicians, they may go out EMS to the hospital for a forensic examination. And then again, all cases are reported to the department for investigation. Patients can also call the health triage line to follow up on a case. We have a sexual abuse or sexual assault advocacy team that actually meets with every person in custody, every patient who has made an allegation of sexual abuse, and we offer resources and additional follow-up appointments.
So how can it be that when someone files a grievance, they don't hear anything back? Because we don't really have, I think, insight into your grievance process. I think we have more reporting from DOC, but how would, if something happened, they filed a grievance, how does that get back to that person?
So we have a complaint process, just a little bit semantics, not so much grievance. But in that case, so it would go through patient relations. And so patient relations would reach out to the clinical and operations team in that facility. And then within 48 hours, they should be addressing the patient complaint. Of course, there's an additional layer for a sexual assault where the patient must be brought to the clinic. And then any investigation would be handled by the department. So we would generally have patients call. They could call the health triage line. They could be brought back to clinic if they want, additional information, or they could communicate that to the sexual assault advocacy team that is reaching out directly.
And my last question, I'm like going down the rabbit hole now, but does CHS do any reporting? Like, who do you report your grievances to outside of your agency?
So we do track our complaints. That's not in an official report, but we're happy to provide that more regularly if that is of interest.
Okay. Yeah, I think it would be helpful just in the follow-up a breakdown of your grievance process, because we have it pretty detailed here, and it would just be helpful.
Sure.
Okay, I'm going to turn it over to members who have questions. Come on, you have a question? Okay, well, there's people online.
Good morning. Thank you for being here. Thank you, Chair. Kind of going to jump around a little all over the place. Most of my questions are follow-ups to the Chair's questions. I just want to go back to the steps of the grievance process, those 4 steps that were articulated. So I want to hone in on how long it takes, specifically how many days for a complainant or a petitioner to fully exhaust all 4 steps in the grievance system. How many days for the complaint, step 1, step 2, step 3, step 4.
So it is our goal to make sure we do a thorough investigation. And so with the first resolution that the person in custody receives, they ought to receive it within 7 days. When it goes to the next appeal, which would be the commandant or unit facility officer, they have 5 days to provide a response, which will be delivered by the OCGS staff. We no longer have the appeal option to the division chief, and then it goes directly to the CORC, the Central Office Review Committee, in which that is an independent, thorough investigation. While it is our goal to make sure that the investigation is speedy, sometimes it requires additional time. I can't provide an exact time frame, but at least
What about an average and a median?
average, I would say 14 to 16 days from the commanding officer's response.
And how long would the commanding officer's response typically?
They have 5 days.
Those 5 days. Okay,
Yes.
so it's 7, 5. You've cut out that 3rd step, and then you're saying that the average is 14 to 16 days on that last step. Now, you had said that, or it was testified earlier that a large portion of these never get appealed. So how many individuals fully exhaust all of these steps?
It is a small percentage. I don't have the exact number. We can provide that. But a majority of our persons in custody do not appeal all of their complaints.
And in your opinion, what do you attribute that to?
They don't wish to move forward. The option is provided to them on the form. OCGS staff, when they're conducting their tours and providing the disposition, they share that they do have access to the appeal process.
But you also, I mean, there was testimony earlier that, that petitioners don't get notified in the cases where they're rejected. So I don't know how we're leaping from people just don't want to appeal when I'm not clear how they know that to appeal.
The complaint process is included in the person in custody handbook, and it's also published in the housing areas. When persons in custody do file a grievable complaint or a non-grievable complaint via the paper-based system, they will receive an outcome. If the complaint is rejected, they are notified. If the complaint is non-grievable and submitted electronically, they will receive either no action or, no response, or an action will be implemented. So they are very much aware of the process if the matter is grievable, and
So
they-
I have two things that I want to
Okay.
address on that. One, I think that we're getting very different communications from incarcerated individuals and their attorneys and advocates as to whether they're actually getting notified of this. I was really blown away to hear that. I'm just going to give a quick example. New York County Defender Services, which, shout out because I used to work there, has 2 full-time people working on just these issues, and they have virtually never encountered someone in custody like that was able to exhaust those steps. They aren't able to do that on behalf of their clients, which I think is actually a problem. But in terms of even the categorization, right? Like New York City is an outlier on how they categorize grievable and non-grievable offenses, and to give you an example of just that, it's different from New York State, where in how they categorize these things. In DC and Massachusetts, it's also different. Right, a sample of 1,500 grievances over 3 years in Massachusetts, only 11% of those were rejected as non-grievable. So I think there's a fundamental problem with how they're being categorized currently, and then with that larger percentage of cases that are dropping into that non-grievable, that process is so opaque. I mean, I have a series of questions just about what happens when you go down the non-grievable track, but it's not. Can I have a couple of extra minutes? Cool. It's just not. The answer is just not tracking with the lived reality. And then I have a question now. You had mentioned that with the new system that came online in January, there was electronic public access to the outcomes of these complaints, but my understanding is that when somebody goes to try to access that, there's no details. It just simply says resolved or pending, which doesn't really leave the person in a position to do the kind of advocacy or understand what's happening to be able to properly take the next steps.
So the question is?
Well, so the question is, like, I mean, how do you find that to be a sufficient way of saying, whoa, this is like really open, transparent public access, when people get one of 2 words, resolved or pending, but no information on how it was resolved or like where in the process it is in that pending?
Well, I'm happy to share that the grievance operation has evolved greatly since it's been implemented. We do provide the definition of what the status is, which whether it's abated, resolved, there's a definition that is provided on the public-facing platform once they input their number. We continue to look through ways to ensure our process is transparent and the outcome is transparent.
So what's the definition of resolved?
I'm sorry?
What's the definition of resolved?
That it was addressed within policy. A departmental policy. That is all the information that we will be able to provide
Okay. I mean,
to the public, yes.
I don't find that to be transparent. I appreciate that that y'all are thinking about a process for how to change how you do this. And again, New York City Department of Corrections really appears to be an outlier on how other correctional systems handle these things. But in rethinking that process, who are you consulting with outside of DOC?
At this point, we're consulting with one another internally. We haven't reached out to other.
So do you plan on consulting maybe groups of incarcerated individuals on the process? Are you planning on consulting the various public defense organizations in the city on the process? They seem like probably pretty important stakeholders when it comes to making this a system that produces the kinds of justice and results that y'all are trying to achieve.
We're open to recommendations, and so I will align internally with applicable leadership to see how we can move forward with that.
Okay, thank you. Thank you. Hey.
Mercedes, Councilmember Narcisse, you had a question? Yes. Okay.
Thank you, Chair. Thank you, and good morning for being here. I try to multitask and listen to you at the same time. So for my question, what specific mechanisms are in place to handle complaints and grievances from individuals in custody regarding health care services?
When complaints that related to medical are received by OCGS, we review the complaint and we task it to the Health Affairs Division. I can defer to DC Saunders for how the complaint matter is addressed.
Good morning. Good morning, Chair and committee members. So when we receive a 311 complaint, we review it to determine the type of complaint. Is it purely a CHS matter, or is it an instance that involves DOC? And so if it's purely a CHS matter, we will send it over to our colleagues in CHS to address. If it's an issue that involves DOC as well, then we will refer not only to CHS, but also the local facility leadership to make sure that the issue is investigated.
Do you have statistics on the amount of complaints made regarding healthcare services, whether both?
Yes. Hi, Councilmember. So complaints that come in specific to healthcare, so I referenced in my testimony, so those would be routed through our patient relations department. So I have data on last calendar year. So we received 4,643 complaints about health services. And so the way that is addressed is that an RN investigator would contact the clinical team, the operations team in the facility where the patient is housed to address within 48 hours the patient's concern. It's also investigated to identify any areas for improvement within CHS.
What is the most common complaint regarding healthcare services?
So we receive complaints about medication, about access to care, and about quality of care. Those really, run the gamut. Just as any of us in the community are concerns about healthcare, it may be the dosage of a prescription. If it's around an access issue, that's something that would be addressed on the local level. So the clinical team, the operations team would work with DOC leadership, potentially the clinic captain, the tour commander, and can discuss access that way. You may be aware we produce a call down list every morning to the department for patients who should be brought to the clinic for routine care and follow-up care appointments. That's separate from calls made to the health triage line. So those calls, when a clinic appointment is made, the aim is to see that patient that day or within 24 hours, depending on clinical need. So if a patient is experiencing, a lot of back pain, that would be that day. If a patient, has a rash and no other concerning symptoms, that could be 24 hours. And then there are also triggers as the nurse is putting it into the health record if it is a medical emergency.
Last time I was upon my visit, the complaint that I was hearing directly, it's when the appointment come, it's just like they don't have no help, no assistance to get to those clinics. Is that how you're working on that? Because I know last hearing, I heard that the effort was going to be made, because when we're talking about health, I don't know if you know my background, I'm a registered nurse. So when people complaining, because the problem that I have the most, let me be honest, when people's health is not being taken care of wherever they are, they're coming back to those communities, and some of the communities don't have access to healthcare, period. So it becomes worse. It's just like we're not spending our dollars wisely, because it is cost effective. When you come back to the community and you come back worse, it's just like not helping anyone. So as a nurse, it bothers me, like when folks are in your care and they're not getting access to health care, because without health, we're nothing. And on top of it, it's not wise to be penny wise in a way, like you don't spend the time to give the person the care, and when they come out, it's a dollar foolish. So do we have staff? Chair, can I finish my thought? Do you have enough kind of staff now that encourage it? Because we're going through a time that's different than ever before, because we've never been to a pandemic. And we my experience, a lot of folks have different issues that prevent them from actually access the care. Either they get up in the morning, the mindset is not all together. So do we actually making the effort to get those folks to this appointment?
Yeah, so as a public health person, I definitely appreciate your comments. And while we wouldn't consider jail an ideal place to receive medical or mental health care, we do view it as an opportunity because people coming into the city's custody tend to be vulnerable populations. More than half of our patients have mental health needs. Many have substance use needs, histories of trauma. So we do look at it as an opportunity to provide care and then hopefully the continuity of care once they're back in the community. In terms of access to care, like literal production to the clinic, I'll turn to DC Saunders.
Thank you so much for that question. So we agree that all people in custody should have access to high-quality medical care, and we work diligently with our partners in CHS to ensure that people in custody are produced to their clinic encounters if they choose to go. For those that do miss a clinic encounter because there's no officer available to escort them, DOC and CHS work together to produce that individual as quickly as possible, either later in the day or possibly the following day within that 24-hour cycle. So I think we've made really good progress in ensuring that staff are available to escort individuals to the clinic. In 2022, there were approximately 6,000 instances of missed clinic encounters due to a lack of escort out of approximately over 500,000 scheduled encounters, and so that was about 5.2% of all non-production. We made great progress in 2023. That number dropped significantly to approximately 3,900 out of over 600 or so thousand scheduled clinic encounters. And so that means that the lack of escort issue occurred less than 1% of all scheduled clinic encounters for calendar year 2023. This year, in 2024, the data from January and February shows that our operations continue to improve with approximately 422 missed clinic encounters as a result of lack of escort. Again, that represents less than 1% of all scheduled clinic encounters year to date. So we are making great strides.
And I do appreciate that. Continue to be mindful because those are the same folks that coming back to community that underserved, and it keep going down and down because you receiving people in the community that's not functional, they sick, and then it comes like a revolving door for all of us, like we in a full cycles of people that's not well. And the city, we have to keep it healthy in order to move forward because if people are sick in our city, we all sick. So thank you for your time.
Thank you.
Thank you, Chair.
Thank you, Councilmember Narcisse. Thank you, Councilmember Sean Abreu, for joining us. I'm going to back up just a little bit. I actually had a question for you, Mr. Levine. Based on what your testimony, based on what's available on the department's website, it looks like DOC has not issued any of the required 540 or PREA reports, which are due to the public every 6 months since 2022. Is that correct, or when will that be updated?
They have been updated. They should be coming very, very soon. I know they have been completed. They have been reviewed.
Is there just a reason why they're not publicly available? Okay. Do you know when they will be available?
They are? Wow. Oh, I apologize. I'm not a tech person.
Okay.
I'm told that they have been uploaded, is that the term, to the DOC website.
Okay, we'll check. We'll come back. So I want to move on to questions. I do have a few questions around medical and mental health grievances. I know Councilmember Narcisse touched on some of them, so I'm trying to skip over to some things we haven't touched about. Each month, the council receives a report on missed medical appointments. And in February, the most recent month we have data for, the total number of missed appointments was 11,246. This is a pretty staggering number, and I know the previous commissioner attributed a lot of this to what he saw as the overscheduling of medical appointments. However, in February, that's the month that we're talking about for the data, 2,000 people missed medical appointments, and the reason was listed as other. And in your report, other includes instances where someone in custody chooses to instead attend a work assignment, law, library, school, religious service, or commissary when maximum clinic capacity has been reached, when no escort is available, or when movement is limited due to a lockdown, search, or alarm. So can you provide any context for how often clinical capacity is reached?
So we don't have clinical capacity data. So I think in terms of the volume, the services that we schedule, we do schedule a lot of appointments. In my testimony, I mentioned the 433,000, which we do believe are clinically indicated. But we do recognize that this requires, close coordination and partnership with the department because patients do need to be escorted from their housing areas to the clinic outside of some of the care that we provide on the therapeutic housing units. So I can follow up on specifics. It is coordination around, when our providers are available and when the DOC escorts are available.
That would be great, just because it's as a part of the definition, just understanding how often is clinical capacity reached. That would be really great to have in the follow-up. Let's see, in calendar year 2023, and so far in 2024, this is for DOC, how many missed medical appointments were due to no escort being available to take someone to the clinic? Even just in a year, how many folks are missing their medical appointments because there is not an escort available to take them to the clinic?
So in 2022, it appears that approximately 6,000 instances of missed clinic encounters were due to lack of escort. In calendar year 2023, approximately 3,900 scheduled clinic encounters were missed due to lack of escort, and that's less than 1% of all scheduled clinic encounters.
Okay. And for both of your agencies, do either of you track how often a facility lockdown, search, or alarm results in a missed medical appointment?
So the department continues to escort individuals to clinic appointments during...
No, I know.
During
It's just
so
in relationship to tracking specifically when there's a lockdown, if you do collect that data or segregate it out, in terms of how many medical appointments are missed due to a search, a lockdown, or an alarm.
So between January and February of this year, approximately 300 scheduled appointments were missed due to a lockdown. And again, that represents less than 1% of the total scheduled appointments and
Noted.
only 1% of the non-productions.
Okay. So, we hear reports that lockdowns can last days. In fact, in the lead up to a hearing on education last year, we were told that RNDC, the facility that holds young people on Rikers Island, have been locked down for days. And so it'd be extremely concerning if there was no access due to a protracted period of lockdown. And that's why I asked earlier about how long does lockdown happen, and is phone, what are the justifications for shutting down phone services? So if you're in lockdown for 10 days and no one can file a complaint, there's a medical appointment being missed, or you can't file a complaint through 311 because the phone access has been shut off for 10 days in this using this particular instance, this is a pretty serious, violation of people's access to support or whatever life-sustaining, services that they need.
And I would just mention our emergency care will respond on seeing if there is a medical emergency, regardless of any lockdown status. But your point is appreciated.
Right, but as you know, and as we've seen in multiple situations, including fatalities, things might not be going according to protocol. And certainly if there's no ability to make a phone call, you're not going to be able to respond to emergency. Okay, moving on. The department and CHS recently gave presentations at BOC meetings to describe the differences between sick call, where a person in custody is requesting non-emergency or medical or mental health care, and other CHS-initiated appointments. Can you clarify whether a person in custody can make a sick call request through an officer in their housing unit?
So the answer to that is yes. A person who wishes to go to sick call can simply ask the officer to be taken. And they also have the availability of using house phones to call the health triage line as well to make a scheduled appointment.
And if a person makes a request for medical care through the sick call process, how soon can they expect to be seen by a provider?
So for sick call, that should be that day, provided the department escorts them to the clinic. For calls, I mentioned earlier for the health triage line, so the goal is to schedule that day as well. So it would be put on the call down list, the nurse would that day, or 24 hours for a less urgent medical condition.
And do you track any data on the average time between when a request for care is made and when a person is seen?
So I could get you the time between when this appointment is scheduled. Of course, a patient for whatever reason may not make that first scheduled appointment, but I can see what data is available.
Okay, it would be great to know what tracking you all are doing. Okay. Okay, so for DOC and CHS, missed medical appointments seem to continue to be a pretty perpetual problem. In 2022, stemming from a class action lawsuit brought by Brooklyn Defender Services and the Legal Aid Society, DOC was found in contempt of court for its failure to ensure people in custody have access to medical services. I understand there are issues with overscheduling, with lots of automatic and required appointments, bloating the numbers. However, has either DOC or CHS made any formal effort to categorize and track types of appointments and make sure that production for urgent medical appointments is prioritized?
So we do track, I'm sorry, I apologize for that. We do track non-production and the reasons for non-production, but I want you to rest assured that any individual in our custody that needs access to urgent medical care is provided that care. They simply need to go to the housing area officer and request to be taken, and if that officer notices that an individual is in distress, that person is taken to the clinic immediately. Or if that person is in extreme distress, they would activate in a medical emergency, in which case our colleagues from CHS would send an emergency medical response team to the site.
Okay. I understand what your policy and protocol and intentions are, but obviously that's not actually what's playing out. My question was, has there any formal effort been made to categorize and track types of appointments?
So we do track the types of appointments. You're referencing the production to the
Or the production to urgent medical appointments?
So we schedule, routine and follow-up care according to, the community standard of care. The calls that go into health triage, those would be that day or within 24 hours, and then emergency care would be addressed immediately.
Okay. Our analysis of the available data on grievances showed that proportion of complaints coming from people housed in mental observation units has been steadily rising since 2020. This is concerning because mental observation units are the least intensive housing option for people who have been diagnosed with serious mental illness. And according to testimony DOC provided in October last year, mental health observation units had the capacity to house 496 people. Of that population, there were over 1,000 grievances filed from January to March of this year. So I was wondering if you could break down the nature of both the grievable and non-grievable complaints that are coming from individuals in mental observation units, or even just the top 3 categories of complaints.
Hi. So the complaints fluctuate, and for persons in custody in specialized housing areas, they typically complain about where they're housed. So I would say the top 3 complaints are medical, H&H related, environmental, and sexual misconduct.
Medical, H&H related, environmental, and what was the last one?
Sexual misconduct.
Sexual misconduct. Okay. And to clarify, yeah, we were just starting to clarify environmental. Can you break that down a little bit more? We had talked about it in our prep a little bit to wanting to understand.
Environmental is directly related to facility cleanliness, and so those complaints are tasked out to our environmental unit to address whatever facility cleanliness is a concern.
Okay. So for CHS and DOC, can you provide any examples of concrete actions taken to address these issues identified in grievances filed by people in the MO units?
So any trend that OCGS sees, we review the data, we identify key issues, and we forward it to the applicable unit to implement appropriate action, and they take their steps accordingly.
Okay. So your top three, one of them is sexual abuse or of a sexual allegation nature. How are you all handling that if it's a top three?
Once OCGS receives the complaint, we notify applicable leadership of the trends to make them aware, and then it's to inform their plans of action. I can defer to AC Levine for how that is addressed.
When we get a complaint from, well, let me just back up. We have a supervisor on duty in my PREA investigation unit from 0700 hours to 2200 hours. When we get a complaint routed to us from OCGS through the 311 system, we look at it and we actually transcribe it. We will then assign 2 investigators who get dispatched to the facility to interview the victim or the caller. Simultaneously, before they leave our office to go to the facility, my tour commander will call the facility tour commander and let them know that we are going to investigate whatever you use sexual abuse allegation, and we would identify the person in custody, and we would request that the facility take the necessary action to remove that individual to the clinic and also make arrangements to rehouse that person so they wouldn't be put back into the same situation with their violator or perpetrator.
And what's the time period on that? Like, what's the average turnaround?
We have, well, I'm going to give you the PREA standards are 72 hours. We respond within 24 hours. If we get something that's serious, we will prioritize it. But in any situation, we will take immediate steps to help ensure the safety of the caller and the person in custody.
And for the trends that are emerging, the top 3 complaints in the mental observation units, I mean, is this consistent? Are these top 3 consistent over multiple years, or is this a new trend? For example, are allegations involving sexual abuse or assault sustained trends in complaints from these units?
I would say that the complaints continue to fluctuate. Maybe it would be the top 3 or the top 5, but they do fluctuate for these specialized housing areas.
Okay. Yeah, it's pretty, I mean, it's just wildly concerning to have a top 3 complaint be sexual assault and abuse, particularly coming from mental observation units. And I've heard, the logistical steps to process a grievance, but I haven't really heard what is the, systemic or operational change that, ends the trend in the unit or across the island at large. So I'm going to move on to
Good morning,
Yeah.
ma'am. Chief Rumbert. So to answer that question, as far as systemic change, is that, first of all, the agency has a zero tolerance policy for sexual assault, harassment, or sexual misconduct, and we will prosecute to the fullest extent of the law. That's number 1. Number 2, all departmental staff that eyewitness is notified and or is told of any sexual misconduct, harassment, assault, that person in custody is removed immediately from their dormitory bed or they cell and place in a secure location, and the supervisor will be contacted to escort him or her to the clinic to be evaluated. Once they're in a clinic, we then will immediately notify SIU PREA unit, as well as secure that area for any evidence preservation, and also we will remove the person in custody to another unit. So with that said, we do take it very, very seriously, and we do act immediately should, during the tour, any of those actions are happening, eyewitness, told, or informed.
Like I said, I appreciate the breakdown of the logistical procedures, but what I'm suggesting is that, I mean, in light of over 700 allegations, you've got a trend in your mental observation unit. Also, staff, female officers have been assaulted. So there is an issue here on the island where sexual assault and abuse is systemic. It is loudly speaking to all of us just in the data and the numbers. And the grievance process, although there are some timely measures in it, is not necessarily, there's not a positive feedback loop here coming to stop a situation that's happening on a systemic level. So that's what I'm trying to get at. But I'm gonna move on to complaints about DOC staff. So in our review of the data since 2020, nearly a quarter of all non-grievable complaints had to do with a DOC staff member. Depending on the nature of the allegation, complaints related to staff are referred to the investigation division or a facility commanding officer for review. When a person in custody makes a complaint against staff, it's a very sensitive situation, and we've heard a lot of stories of subtle and not so subtle ways in which retaliation occurs. DOC's grievance directive states that no reprisals by staff of any kind shall be taken against an inmate for good faith use of the grievance and request program. However, this is, clearly there's been a breakdown. So when a facility commander is informed of a grievance filed that alleges improper behavior by a member of their staff, how are they instructed to handle that investigation? And specifically, how do they ensure that their investigation will not result in a person in custody being identified as having filed that grievance?
I believe when we get these allegations, they're not, when they get called into Central Operations Desk, they're called in as just confidential allegations, and the identity of the person making that call, that allegation, is not identified. It is identified to us when we get it. When we get it, we will call back the person calling it in, the tour commander of the facility. They will identify it to us over the phone, and that's how we will direct them. There's something that we have called the separation order. We will then issue a separation order that will take the violator away from the victim.
And has DOC ever imposed any formal or informal discipline against an officer for engaging in an act of retaliation against a person in custody who filed a grievance?
I don't have that specific information available, but in the last 2 years, my unit has, we refer acts of misconduct by our officers to our trials division. We have 53 cases currently in the trials division against officers.
Out of how many people?
I don't have the specific breakdown. I do know that the number is 53 from January 1 of 2022 to right now in 2024. So there have been 53 cases that we referred to them for different violations of different types of rules and regulations.
I think it would be, in the follow-up, it would be good to hear, since maybe 2022, how many data on how many disciplinary actions have been taken, formal or informal, against officers who have engaged in retaliation in the follow-up. We'll send it over.
Okay, yes.
As part of the consent judgment in the Nunes case, the department was required to develop and implement an early warning system to identify staff members whose conduct warrants corrective action and provide additional guidance and mentorship to those officers. Are grievances filed against staff members reviewed to help determine which staff members might benefit from additional support?
Once a complaint is received about a staff member, it is forwarded to the Special Investigation Unit to handle accordingly. So I will defer to AC Levine on how that information is shared internally.
Whenever we get, I also run the misconduct arm, it's called the intelligence team, whether it be a prior allegation against the member or whether it be any other allegation, our first responsibility is we call the Department of Investigation. There's a DOI duty team that works 24 hours a day, 7 days a week. So anytime we get an allegation against any staff member, whether it be civilian, whether it be contracted, someone like who works there fixing things, someone from CHS, we have a responsibility and we refer that immediately to the Department of Investigation. They will review it, and after they review it, they will either give it back to us or they will take it and give us what they call a stand-down order. So there is the review process to see if there were recidivist staff members committing these acts.
Okay. And do you know how many people are, I don't know how it looks on the back end for you all, but do you know how many, let's say, staff members are kind of in your early warning system currently?
I don't have that information. Okay. That would be something DOI does keep that form of data. So that would be, they would be the best people to let you know who their, would I be safe to say recidivists are?
And then I know there's like guidance and mentorship, but can you just explain a little bit more what that looks like? What are you providing? Someone's on an early warning system, maybe they've got a couple grievances filed against them. What specifically is being provided to that individual that is course corrective?
Well, most of that would be done by our training unit, but I can let you know that my PREA compliance team we do facility training, we do supervisory training, and when the officers come every 2 years for their they have to do a refresher, PREA refresher. My team does the I guess they're the facilitators of the training. So that is what my team does for training officers in this manner.
Yes, ma'am, Chief Member. Also, we have EISS, the early warning that you were speaking about as well. That unit also handles that as well, if any issues concerning that. And what they do, they take the information from the facilities, they review it to make sure that, the member, whenever the member service is in, make arrangements for the member service to have a mentor monitor them. So that's also available as well.
And do you know how long that kind of period of being engaged with this early warning system can go for? Like, what's an average? Someone who's exhibited signs that triggers this, like, how long are they a part of some kind of program?
Well, I don't have the correct number or the correct data. However, it could be from any time that the trials and litigation and that unit comes together and say the member of service will negotiate plea agreements from here to here, and that EISS will handle it to when they start to finish. So I don't have the data to tell you exactly how long, and it's on a case-by-case basis.
Okay. I'm going to open up again for questions. Councilmember Caban has questions.
Yes, thank you. Just very quickly, a follow-up is, are accused officers suspended while an investigation is ongoing?
We have suspended officers yes, we have done that.
Okay. What number or percentage of that over a period of time? And is there a breakdown of, like, how you make that determination? Like, is it based on the nature of the allegation? Is
Yes,
it based on the person's history of being accused of misconduct or abuse? Like, how is that determined?
during our preliminary investigation, if we believe that we have a founded sexual abuse case, and we usually through the victim statement plus other evidentiary video, phone call, outcry, other witness interviews, we do witness interviews of other persons in custody who are in the housing area.
So
and if they can corroborate, we have suspended people.
Well, but based on that, it sounds like it would be a period of time between an accusation and whether you decide at some point in the investigation that an accusation is credible enough that you decide to suspend someone. Is that correct?
That is
Yes,
correct.
Chief Schwembert, ma'am. So if it's a preliminary investigation and you cannot make a determination of that determination, the member service can be modified and taken out of the facility and placed on modified status.
Okay.
And then when the
Is modified is different than a suspension, correct?
Correct, ma'am.
Okay.
They no longer are assigned to a facility. It's assigned to an area with just modified officers. So it's not like when we have the member of service remain in the facilities until a final determination or for final outcome. So we will modify the member and suspend, or we just will suspend the member, and that is determined on a case-by-case basis.
And are they suspended with or without pay?
Well, that's what would be without pay. All right, so when modified, you're still paid, but you're modified until a final determination. If it's the captain, if it's during the week, we have to suspend. We will suspend with pay from, if it's during the week, we have to immediately suspend. A supervisor can be suspended only on a Sunday, 001 hours, 7-day increments. So at times, I do not have the data in front of me if any of that has transpired as far as the number of supervisors versus captain and thereafter.
So can we get that data set? Like, I am curious to know over the past year, for example, what percentage of accusations resulted in a suspension, and what was the average length between that accusation and the moment of suspension? How many times was an accusation determined to be founded and credible, but an employee was not suspended, and vice versa? Like, there's just a whole data set here that would be really helpful and illuminating about people's experiences. And then my last thing is just a comment. I found it really interesting that you mentioned recidivist staff members, and I just feel like that's something that shouldn't exist. I think that if you are a recidivist in abusing the people that you're supposed to be keeping safe and protected in our correctional facilities, you probably shouldn't have that job. Thanks.
Thank you, Councilmember Caban. Okay, I'm getting down. We're getting there. I just have a few more questions, and then I think we will switch panels, I believe. So according to the available data, over the last 4 years, there has been a significant increase in grievances filed related to commissary operations. In fact, there appears to be a spike in grievances related to the commissary in April 2022, right around the time that the contract began with the Keefe Group to operate the commissary. Commissary grievances post-2022 continue to be higher than they were previously. Along with this alarming grievance data, there was also an investigation conducted by the news outlet The City, which exposed the high prices and poor service by the Keefe Group. And last month, the Comptroller's Office cited a myriad of problems to justify their decision to reject a contract renewal with Keefe. Despite all this, the DOC recently decided to move ahead in awarding the Keefe Group another $33 million to continue running the commissary. So my questions are, we've received a lot of anecdotal information about people receiving expired or incomplete commissary orders with little access to recourse. When a grievance is filed that is related to the commissary, how does DOC address the problem with the Keefe Group? Do you follow up to ensure the issue is resolved?
Commissary complaints that are received, when anytime there's a new operation, it is expected that it takes time for the operation to be familiarized by the persons in custody. Since the relationship with the Keefe vendor, OCGS has monitored the complaint trends, monitored the frequency. We have had initially meetings once a month to discuss some of the concerns of the persons in custody that we were seeing. As it trends downward, we have meetings maybe quarterly to address some of the concerns. Most recently, we saw a trend in expired items or just not having packages delivered. We spoke with leadership of Commissary, and they're actively working to address it. This happened within the last 45 days.
And when you say you were having those meetings, that was with who? Keefe or with folks in custody?
So the meeting is with the leadership who manage the day-to-day operation of it to see
commissary.
where the concern is. Keefe, the conversation has not been directly with Keefe, with OCGS. It's my understanding that our internal leaders that oversee Commissary have brought our concerns to the Keefe vendor.
And just from my understanding, particularly related to expired food, is expired food arriving on site expired, or is it expiring while being on site? I'm just trying to understand if people who are running the commissary day to day aren't clocking that.
It is my understanding that deliveries are done in a timely fashion and on the scheduled days. From my experience and what I've observed, it's when the package is received by the person in custody.
Okay. So as part of the comptroller's letter justifying the decision to reject the contract renewal with the Keefe Group, he cited the department's failure to follow the city's procurement to conduct annual performance reviews and said this indicates that the agency, the vendor's performance when affirming its responsibility. How do you justify renewing this contract when people in custody have been increasingly raising concerns about how the commissary is being operated?
Good afternoon. We're reviewing that at this time, and we cannot provide a response to that question at this time, but we will circle back with you.
And what's a timeline on a response?
Can you give a closer date where we can provide you a response of when this timeline?
I'm sorry,
Can we provide you that by close of the day when we can
Oh,
respond
by close of day.
to your timeline?
Okay, understood.
Not saying that we give a response to your question.
No, but at the end of the day, you will let me
Yes.
know when we could get a response.
Correct.
Understood. Thank you. Okay, in the DOC Commissioner's letter to the Comptroller's office, she asserted that DOC has constantly monitored the vendor's performance, and DOC maintains the ability to reject or accept the vendor's listed price for commissary items. Can you provide the committee with an example of actions you've taken on behalf of people in custody to remedy issues with the vendor's performance or request price adjustments
We'll add that on there as well,
at the end of the day?
to provide you a time to respond to your
A
question.
time for a response. Love that. It's a new line. Okay. Quick question. How many people work at OCGS? What's the head count?
My apologies. Currently, we have 27 budgeted lines.
Okay. And how many grievance coordinators do you have?
We have 13 non-uniform staff.
Okay. Okay, I just have a few more questions related to voting.
I'm sorry?
I have a few more questions related to voting. So are you aware of anyone generally filing a grievance related to not having access to voting?
I cannot confirm or deny that we've received complaints related to voting. We can circle back with you.
Okay, if there's a, yeah, it would be helpful to know if there's a clear process for filing a grievance for someone who feels like they've been denied their ability to vote. It's obviously it's a big year, it's an important year, and so folks who are on Rikers, who are who have the right to vote, certainly should have access to the poll, and so it would be really important to understand if there's a process for for filing a grievance against that.
Understood.
Are people informed of their voting rights while they are in DOC custody?
Yes, ma'am.
Are you aware of anyone receiving ballots through the mail?
I'm sorry, can you repeat the question again?
Do people in custody, have you heard of people in custody receiving ballots in the mail and being able to vote by mail?
I cannot confirm or deny that, but I will get back with you.
Okay. Okay, I'm going to turn it over to Councilmember Caban for another round of questions.
Yes, thank you. I just wanted to follow up on a couple of the questions around voting. You said people are aware of their right to vote. How do you do that? What does that look like?
The person in custody are aware of the right to vote. It starts off by when it's located during the new admission process when we have a sign. The sign as far as right to vote is located in the housing areas. Right to vote, as well as the new, as I stated, new admission process. A new admission process when them coming into the facilities as well.
I know that the Legal Aid Society did a survey of a number of their clients, asking them whether they were given materials, saw materials, had access to ballots when it came time to vote, and the results of that survey didn't tell a story of not even close to a majority of the folks knowing that they could vote or have access. So I think there needs to still be a good deal of work done there. They've repeatedly made requests to have a voting site on Rikers Island. What's DOC's position on that? Would you support there being a voting site on Rikers Island to make voting more accessible?
We will look into that recommendation and get back with you.
Okay, thank you.
All right. I think those are all my questions for you all. I think we do have follow-up items. I don't know if we've actually received follow-up items from the executive, or the preliminary budget hearing. So, we're still waiting for the last follow-up. And hopefully we could get this follow-up in a more timely manner. I know you're rolling your eyes, but I mean, this is like public information. This is an opportunity for people to understand what's happening in these agencies. So sorry to inconvenience everybody, but we do need the follow-up information. And there are some non-compliance issues that we've discussed, and it would be great. Can't wait to get those reports in spreadsheet format. Love me some Excel. And looking forward to hearing from you by the end of the day from when we will hear about a timeline for some other things. Thank you for being here.
Yes, ma'am, thank you.
I think we're going to take like a 10-minute break, and then we'll bring up BOC. Thank you. I don't need the gavel, right?
Yeah, this is the second.
Okay. Okay, we're going to start our panel from the Board of Correction. I will now just introduce our first panel of administration witnesses and ask the committee counsel to swear them. So with us, we have today from the Board of Correction, Jasmine George-Yiya, I'm so sorry if I'm butchering that, Executive Director, Melissa Cintron-Hernandez, General Counsel, Barbie Melendez, Director of Public Accountability, and Barty Bailey, Director of Violence Prevention. Great name. And I will now turn it to committee counsel to swear you in.
Okay. If you could all please raise your right hands. Do you affirm to tell the truth, the whole truth, and nothing but the truth before this committee and respond honestly to council member questions? Noting for the record, all the witnesses answered affirmatively. You may begin your testimony.
Good afternoon, Chair Nurse and members of the New York City Council Committee on Criminal Justice. I am Jasmine Georges-Yiya, Executive Director of the New York City Board of Correction. I'm joined today by BOC's General Counsel, Melissa Cintron-Hernandez, our Director of Public Accountability and Oversight, Barbie Melendez, and our Director of Violence Prevention, Bart Bailey. Thank you for the opportunity to testify today. Despite a lack of resources, BOC continues to carry out critical independent oversight of the city's jails. The board has monitoring staff assigned to each jail, serving as the board's eyes and ears, and identifying systemic issues that impact people in custody and staff. BOC receives complaints directly from individuals in custody and New York City Department of Correction staff through various channels, including phone calls, emails, visits to our website or office, and in person during BOC staff's daily tours in the jails. Our staff is charged with investigating and resolving issues that are brought to their attention, including issues with the DOC grievance system. My testimony today identifies certain systemic shortcomings in the grievance process. Our goal is to shed light on these issues to prevent their recurrence. A person in custody can file a grievance by filling out a request for grievance slip, completing a grievance statement form that should be available in their housing area, or by writing their grievance on any available piece of paper. All jails are required to make these forms available to people in custody. However, paper grievance forms are rarely readily available in the housing areas. Furthermore, the locked grievance boxes where these forms are submitted are often located in restricted areas, making them difficult for people in custody to access independently. Many facilities have only one box, making it inconvenient for submission of a paper grievance. Alternatively, a person in custody may call 311 to file their grievance electronically. These grievances are logged by the 311 operator, bypassing barriers such as needing access to a corridor to reach a grievance box in the jails. Grievances received through 311 are reviewed by the department's Office of Constituent and Grievance Services, or OCGS, and forwarded to the staff at the relevant facility for grievance review. Of the 41,079 grievances filed in calendar year 2023, 36,669 were electronic, and 4,410 were on paper. This trend continues in 2024. OCGS reports that out of nearly 9,200 grievances filed between January 2024 and March 2024, approximately 78% were filed through 311, while only 10% were filed using the grievance box. This suggests that calling 311 is a preferred method to file a grievance because it's more efficient than waiting for a grievance officer or coordinator to visit the housing area or the locked grievance box. If a person in custody is not satisfied with the outcome of an investigation or resolution to a paper-based grievance, they may check off a box on the grievance disposition form requesting to appeal the determination.